Good afternoon. Welcome again to another week of Florida Appeals Journal. I hope everyone is continuing to do well, as can be expected under the circumstances we all find ourselves in. So let's take advantage to and spend more time to learn new things that helps us in our practice and in the litigation world at both the trial and the appellate courts. Today, I want to talk about extraordinary writs, and specifically the writ of a certiorari, petition for writ of certiorari. What does that mean? And the writ of certiorari is one of several extraordinary writs, which means you don't technically call it an appeal, but it is a proceeding. It's an extraordinary writ proceeding that you bring to the appellate court under very limited circumstances, and we're going to discuss that today. So you'll know the answer to the question on what is the petition for writ of certiorari all about. When can I use it? What's the standard of review for a petition for writ of certiorari? What are my chances of prevailing on that, and what are the procedural technicalities for bringing that in my case? And the petition for cert, so that you know you can use that, you still have a 30-day rule, which is 30 days after rendition of the order that you seek to review. And you'll usually do a petition for writ of certiorari during the pendency of litigation in the trial court. It can be pre-trial, because normally in your standard appeal, as you know, you have to wait for a final judgment, and then you can appeal that. There are also, and I know I'm giving you some basics, I'm sure you already know, there are also certain defined non-final orders that are appropriate for a non-final appeal, and they're laid out in the Florida Rules of Appellate Procedure, and they're very specific, very narrow, and you have a little bit different timelines on a prep of any kind of record there. But the petition for writ of certiorari is a very unique creature. It has its own rules in the Florida Rules of Appellate Procedure. The definition, okay, a writ of certiorari is used to remedy the trial court's action that exceeds its authority or departs from the essential requirements of law, and there's no alternative legal remedy. So you're going to file a petition for writ of certiorari if you've got an order that is a really bad order, and it's not the type of order that can be remedied by a subsequent final appeal in the case. Okay, that's very, very important. And number two, it has to result in irreparable harm to your client. A lot of cases, we'll talk a little bit about that, defining what is irreparable harm. Okay. But those are, and it's a very strict standard, much stricter than review, on a normal, on an appeal. But you've got to meet those requirements. And again, the timing, you file it 30 days after rendition of the order to be reviewed, and you're not filing a notice, right? Not a notice of appeal. You're filing a brief, although it's a petition, so don't call it a brief. And it could be, 30 pages, 40 pages, 10 pages, but that's your argument. You're going to lay out the facts. And there are forms you can follow in all the books, but you're going to put your statement of jurisdiction, your statement of the key facts, and you're going to put your argument. You're going to have to convince the appellate court how this order that you're appealing does depart from essential requirements of law, is causing irreparable injury to your client, and it can't be remedied by a subsequent appeal. Also, the record, you have to do an appendix, okay? So the clerk's not going to prepare your record for that. So when you do, you file it within that 30 days, you're also going to file an appendix that's going to have the key record documents that support your argument. So you've got to have everything done fast. And if the appellate court believes that you have made out a prima facie case, so on the surface looks like, hey, they think you're right, they'll issue an order to show cause, and then they'll set up a schedule for when a response will be due from the other side and when a reply will be due, and then they'll render their decision, and they can grant the writ, or they can, of course, deny the writ. And a couple little things to keep in mind, that if a party improperly files a notice of appeal instead of a petition for cert review, the appellate court shall treat the cause as if the proper remedy had been sought. And that's Florida Rule of Appellate Procedure 9.040, parens C. There are many cases on that. And standard of review, again, I think we talked about, departure from essential requirements of law, got to be a material injury. And you can't be trying to use it to try to circumvent the Rule 9.130, which talks about the non-final orders that are reviewable. Then a little something too, I'll make it more detailed. There's a petition for cert process. Now I'm talking about, when we're talking petition for cert, you're normally talking about going up from your circuit court, traditional circuit court, up to one of the DCAs, District Courts of Appeal. But you also have appellate review that a circuit court does to county court decisions, to administrative agencies. And that's a first instance. They have the circuit court, and those particular kind of cases, they use the circuit court as the appellate court of the first instance. You can then take a petition for cert to the district court to review the circuit court's decision. But again, very different and a much more limited standard of review there. And and just because you disagree with what the circuit court did in its appellate review capacity, that's not enough. All right. You're going to, there's going to have to be a denial of procedural due process, departure from essential requirements in such a way as to cause a true miscarriage of justice. And you have to look, the cases, because that is very, very narrowly construed. And the district court's standard of review is known as a second tier certiorari relief. If you have circuit court hasn't even followed the right law, made a blatant error of law, and there's no question that you may be able to show is a miscarriage of justice sufficient to show a departure from essential requirements of the law and meeting that standard of review. What I find interesting is that certiorari jurisdiction, you really can't use it to create new law where the order on review recognizes the correct general law and has applied the correct law to a new set of facts. Certiorari isn't the avenue of relief you want for that kind of issue. All right. And I always thought this is interesting too. If you want to challenge the constitutionality of a particular law, statute, you have to do that through an original proceeding before the circuit court. You're not going to use that on a petition for cert. So I tell you these things because people have tried to use petition for certs for these issues, and you can't do it. All right. So let's look at some examples. This is very helpful, I find, of when can you use the writ of cert. You can have issues regarding a motion to withdraw as counsel. That's denied. People have used cert for that and been successful on that. Order granting or denying motion to disqualify counsel. You can do that too. And I've seen them use discovery orders that violate constitutional right to privacy, discovery orders compelling production of documents by a non-party. The biggest, I guess the most popular reason it's used is to deal with cat out of the bag discovery. So you can have a trial court issues an order compelling production of maybe some sensitive documents, trade secret, for example, fundamental privacy issues. Then you're going to want to petition for cert. If you think the court was wrong on that, the trial court was wrong, you definitely want to get that in a petition for cert. That's classic use of petition for cert because you're going to be sustaining irreparable harm. The cat's out of the bag, so you can't put it back in. So that's an example of irreparable harm, and it's not capable of remedy by final appeal. So that becomes really critical, and you're going to also want to consider when you do petition for cert, you want to try to get a stay order if you can from the trial court and then from the appellate court. And if it's meritorious as a general rule, you should be able to get the stay order but they are very difficult. Um, and I've seen where orders granting post-trial interviews of jurors, that can be used, orders compelling paternity tests, orders denying motions to consolidate or granting motions to sever. There have been petitions that have addressed those issues, lis pendens. This is very traditional use, orders denying a motion for summary judgment based on plaintiff's failure to follow the medical malpractice pre-suit screening requirements. One issue I think is fascinating is where constitutional rights are deprived or delayed while litigation is pending in the trial court. I think that's very important. I don't think you see a lot. I think people usually think, oh, we can't really do something about that. They try to argue, well, there's no irreparable harm, or can't you remedy that by appeal? But really, the violation of a litigant's constitutional rights, as soon as it's done, that's the material and the irreparable harm, and it can't be remedied by appeal because it's ongoing. And there are many examples of that, but I'm going to just cite a couple cases for you. You have, if the trial court removes a fundamental constitutional right of a litigant, it could be in a pretrial proceeding, it could be during trial. Generally, we're dealing with pretrial on this. That in and of itself constitutes irreparable and material harm. And that harm continues throughout the proceedings and is being done now. So a final appeal at the end of the case really isn't adequate to address and resolve the current and ongoing harm to that individual. I would refer you to the Belair case, Belair v. Drew, 777 2nd, 1164. And in that case, the Supreme Court recognized that certiorari is proper and irreparable harm can be presumed where an order requires action which implicates an individual's constitutional rights. And in that case specifically, the court held holding that cert is available to review a continued deprivation of rights under an unconstitutional statute. Padovano, a 2019 edition, that's in his Florida Appellate Practice, section 30, at I believe page 5, recognized that denial of due process is reviewable by certiorari, and denial of due process is not the kind of injury that can be corrected later. It just can't. So by continuance of the proceedings, any infringement during those proceedings cannot be remedied on appeal after conclusion of those. So Belair cited several cases that I think specifically address that issue. And you have others. There's this Russ v. Brooksville, 109 Southern 3rd, 1266. And that's First DCA 2013. We'll try to put some on the site also, which talks about, denying claimant's motion for an evidentiary hearing, right to call witnesses. You deprive that of a litigant. You've deprived their due process rights. And, that there may be a pretrial ruling on that. And these cases show that certiorari has been entertained for those types of issues. So that's actually very significant because it actually happens more often than you realize. And cert review is typically the relief you want to seek. So that in today's and this week's journal, we just wanted to address the petition for cert. That's probably the most common, most popular extraordinary writ proceeding that occurs in the appellate courts, and it applies to the circuit courts and the district courts of appeal. It used to be years ago, people would use petition for cert to try to seek review in the Supreme Court, but the Supreme Court ended up putting an end to that. Actually, it was used to challenge per curiam affirmances out of district court, and that came to an abrupt halt. So you're generally going to be using this remedy in the district courts of appeal, and if you're dealing with county court decisions and administrative decisions, then you'll be in the circuit court and the circuit court's appellate capacity, and then you'll go up to the district court if you meet the stringent standard there for second tier certiorari review. That's our question resolved for this week. If you have any questions, again, submit them to our site and we'll do our best to get to them. Thank you very much, and we'll see you next time. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.